What people don't understand, and I think the media should understand this, when government roll out certain programs and policies, you see, I read in the headlines, oh, federal government to... That is not the story. The story should have been federal government rolls out funds to further enslave Nigerians.
Here is the final summary of Inec's final return address to Labour Party Obi submitted at the appeal court. So, Inec has finally released their final address to the Labour Party. Inec introduced their final written address by mentioning that the petition of LP Obi challenges Bat's declaration as the winner of the presidential election conducted on February 25, 2023. They mentioned that their written address will demonstrate how the petitioners, LP Obi, failed to show how they scored majority of the lawful vote cast at the election. They further stated that the petition filed by LP Obi lacked merit and should be dismissed. In their brief summary of facts, they mentioned that as regards the issue of qualification, they tendered a letter dated July 6, 2022, which enunciated a voluntary withdrawal of Shettima as a senatorial candidate, and that this letter was tendered as Exhibit RA2. They further mentioned that the alleged order of forfeiture by the U.S. District Court, which was raised as an issue to disqualify Bola Ahmed Tinubu, was never brought to its attention. On the argument of corruption practices and non-compliance with the Act, they mentioned that the Labour Party, Obi, argued that they were mandated to use technological devices, hence they used the beavers for accreditation, verification, confirmation and authentication of voters, and that the presiding officers were mandatorily required to transmit or transfer. It is not transmit or transfer, it is transmit and transfer. Both of them must be done according to the law, INEC law. Transmit and transfer, not transmit or transfer the result of the polling unit directly to the collation system of INEC. In their defense, they mentioned that collation of the election result remained a manual process and that failure to upload the presidential election with the beavers was a technical glitch. They further mentioned that the obligation to electronically transmit or electronically collate result of the election had been judicially determined by the Federal High Court, which leaves electronic collation and transmission to be discretion. As regards non-compliance, they argued that all the achievements of the LPOB were false and unfounded. After the brief summary of facts, they addressed the evidence of the parties under different subheadings, starting with Labour Party Obi's evidence on non-qualification. They mentioned that the Labour Party Obi led evidence through PW1, PW3 and PW12 to deny. Under cross-examination, PW1 struggled to deny that his evidence was simply his legal opinion and that he had not been an author of any authoritative book on constitutional or electoral matter. He also admitted that the U.S. District Court order of the judge that allegedly granted the forfeiture order was not registered in Nigeria. On the LPOB's evidence on non-compliance, PW2, a software engineer, gave no details as regards his qualification, but pretended to give evidence in his alleged area of expertise. Yet, having no legal training whatsoever, also gave legal opinion on the Electoral Act 2022. Under cross-examination, he admitted to not being familiar with the beavers and that he could not state all the softwares used by INEC in the conduct of the election. PW3 on non-compliance tendered a video recording marked as PBH3 and PBH4. The video showed INEC chairman giving assurance of the transmission of results electronically in the real time. Under cross-examination, PW3 admitted that the chairman of INEC is still alive. PW4, a prof of mathematics, also testified and claimed that they uncovered 10,000 polling unit result out of an alleged 18,099 blood, which is 088 blood result allegedly uploaded on IREV. He later admitted that there was no overvoting in the result. He also claimed his evidence was precise and based on exact data, and admitted that the blood result would not change the content of the original physical result. PW5, who is the director of operation of Arise TV, appeared via subpoena as well to tender a video where the chairman of Inec stated that political parties should make comparison between results uploaded and the hard copies. PW7, who was a staff of Amazon Web Service as well as a member of LP, contested for the election into the House of Representatives. She testified as regards the health of the AWS but admitted that she did not have any access to Inec software infrastructure or cloud trial. She also admitted she was not appearing in court on the mandate or authority of AWS. They also mentioned notably that the statement on oath of PW12 was deposed to on the 20th of March 2023, whereas the report of PW4, which he purportedly alluded to as the basis of most of his conclusion, were incomplete as at when he made his witness statement on oath. In addressing the summary of their INEC own evidence, they mentioned that they called just one witness who tendered exhibit RA1 to PA6. The witness mentioned that there was no electronic collation system. He further explained that it's a technical glitch on election day prevented the smooth transmission of the PU result to the IREF portal. He explained how this was resolved and tendered the Amazon cloud trial of Inec. He stated under cross-examination that he was one of those who designed the e-transmission system of Inec and that IREF was not for collation of results. In summarizing the Shettima evidence, they mentioned that several documents marked as Exhibit RA8 to RA27 were tendered and only one witness, who happened to be a lawmaker, was called to testify. INEC raised 5 issues for determination. The first issue bordered on the qualification of Shettima to testify. To testify. They argued that relying on the Supreme Court judgment in PDP vs Inec, Shettima was no longer a candidate for the senatorial seat as at the time he was nominated as the vice presidential candidate, and that the PEPT is bound to follow the decision of the Supreme Court based on the principle of stare decisis. On the alleged allegation of fine imposed by the U.S. District Court, INEC simply said it was not brought to their attention, but still mentioned that the Constitution was particular about sentences in Section 137, subsection 1 and D. The second and third issue were argued together as they both talked about non-compliance. They argued that LP Obi failed to prove his ground, stating that there is really no obligation on INEC to electronically transmit and collate results of the election or to suspend collation till results are fully uploaded on the IREV. They also referred to Exhibit X1, which is the certified true copy of court judgment in the case of Labour Party vs Inec, which buttressed the point that Inec is at liberty to prescribe the manner in which election results could be transmitted. They also referred to PW4 Exhibit PCD1, which is the IREF's cause investigation document, which shows some data reportedly from results uploaded on the IREF. In the scores inputted on those tables, BAT scored more votes than Peter Obi, and there was no table showing where Peter Obi had more votes or depicting how Peter Obi could have won the election. On the fourth issue, which dealt with majority of lawful votes cast, INEC contended that no evidence was laid in this regard, which is, in effect, means that the ground had been abandoned by LP Obi. They mentioned that PW12 stated clearly that all votes recorded by Inec and scores of the political parties in the election were location and should be voided, included those of Atiku Abubakar. They further relied on the legal principle and states that the claim or defense pleaded which is not canvassed during the trial is deemed to have been abandoned. On the 5th, in issue in relation to 25% in the FCT, they argued that the LP-Obi only had 1/4 of votes cast in 16 states, which is less than the constitutional required number of states. They referred to section 134 subsection 2b, which says 2/3 of all the states of the federation is needed to win. They further replied on section 299 to state that the FCT is just like one of the other states of the federation and does not enjoy any special status. They concluded by stating that the LP-Obi did not make any case for themselves. Well, I'm going to give you the explanation in our next video. Thanks for supporting the Future News. Peace.